Yep.
Awesome.
We're good to go.
Cool, thank you. All right, good morning, everyone. We're going to call this meeting of the TRPA Legal Committee to order. The date is Wednesday, September 25th, 2024. It is 8:30. First item on the agenda is roll call. Catherine, can you please call the roll?
Ms. Fastinos?
Here.
Ms. Aldine?
Here.
Mr. Keycapper?
Here.
Ms. Loomer? Ms. Williamson?
Here.
Madam Chair, we have a quorum.
Thank you. For a few housekeeping items, for members of the public who are joining us remotely, you will find this meeting under trpa.gov under the calendar header. If you want to address the committee, you will have 3 minutes to do so. If you're joining us by telephone, you can dial *9 to raise your hand and be unmuted. Otherwise, you can raise your hand in the Zoom raise hand icon. If you're here in person, we'll call you up when it's time for public comment. Next item is approval of the agenda. Are there any changes to the agenda?
Good morning. No changes. We do just want to note that we would like to go into closed session for
We do
a
need
quick
that.
update on potential litigation.
Great, thank you for that. So we'll make sure to hit that agenda item. Okay, with that highlight, we will deem the agenda approved as posted. We're now on agenda item 2, which is approval of the minutes. We have a draft set of minutes from August 28th on page 9. Anyone have changes?
Oh, beautifully done.
All right, perfect. I will entertain a motion to approve the minutes as presented.
So moved.
All in favor, please say aye.
Aye.
Any opposed? Motion passes. Next, we're on to agenda item 3, which is the informational update on appeal of denial of single parcel peer application 3180 Edgewater Drive, Placer County, California, assessor parcel number 093072041, TRPA file number ERSP 2022-0021, and appeal file number admin 2024-0006. Marcia, if you could please give us an update.
Absolutely. So after our last meeting, we began gathering information in order to respond to the questions that the committee had. And in doing that, I also contacted appellant's counsel because we had agreed that we would gather the information together so that we both had, a full set of information coming into the next hearing with you. And at that time, I think we both acknowledged 2 things. One was that there was a lot of information that we were, sort of looking through to find good answers to all of your questions. And he also requested that we consider potential pathways to maybe resolving this. Possibly with, I think there were ideas about, whether or not if this parcel is eligible for a multi-parcel peer, et cetera, maybe we should talk about these things. I can't answer those questions, really needing Shoreside staff input, and we realized there was probably a little more information that needed to be gathered from them if we were going to explore possibilities of resolution. They requested maybe a continuance would be useful for that purpose. We agreed, and so it will come back at the next committee meeting, possibly with an idea for a resolution, or at the very least with the answers to all of your questions so we can carry it forward.
Great, thank you, Marcia. And you'll notice again, we're agendized just for discussion, not vote on this. Any committee members
Yes.
have discussion?
Well, the key point, I think, for me, Marcia, was whether or not the DBA board ever denied an application for membership. Did we come to a conclusion on that?
We have gathered some information on that. It appears not. But again, I don't want to get too deeply into, responding to those issues because I did tell the appellant's counsel this would be information only. We're just going to give you an update where we are. We're going to have some more conversations. He's very good to work with. We'll get back together and, continue some conversations.
Great. Anyone else? Okay. Thanks so much for the update, Marcia. All right, next we're on to agenda item 4, which is discussion and possible recommendation for approval of internal recruitment to facilitate transition of general counsel. This information can be found on page 109 of your packets.
I'm going to go ahead and step out on this one.
Yes.
And then you guys can text me, Catherine, when
Yes.
you're done.
Thanks, Graham.
So we don't have to follow the rules anymore, right? So council's gone.
Exactly. Exactly.
We have another council. No, you have to-
Brains.
I'll definitely tell
They
them.
actually double team up just so we can. I'm going to ask Angela if you could please come up.
Sure.
Thank you so much. And if you want to, I know Julie was going to start
She
and
wanted
then jump
to.
over. So
Right, yeah, that's fine.
Okay.
I think we spoke about this at our last
Yep.
meeting last month. We did a very extensive recruitment, for some additional legal staff last year. And so I feel very confident in the recruitment that we did and that the internal candidate that we have that could apply for this position would fit into this role perfectly. And so I think it's also important to note that TRPA does not have a budget currently to do an external recruitment for a general counsel position. So that's also a consideration.
Thanks, Angela. And as you mentioned, we did speak about this at the last meeting.
Yeah.
It was also my thought and recommendation. This committee, I believe, also agreed unanimously that this was a good path to go forward. We shared some feedback on why, but I think you had some good reasoning as well that we shared at the last meeting. So, I think this is in line with something we've already discussed, but obviously happy to take any committee member questions or comments at this point. And Julie, perfect timing. Angela just gave us a quick summary. We were just talking about this is the path we've been down, but if you wanted to add anything.
Certainly. Thank you, Madam Chair. Julie Reagan, TRPA Executive Director, wanted just to follow up from our discussion last month and give the committee the opportunity to vet this and then discuss this in the full board meeting. It's on consent. We have had a member of the public request to pull that item from consent. So it's up to the board how to handle that. We will take public comments on that item. But our proposal is to have an internal recruitment and to get your action today that would allow the agency to post a position internally. And then maybe I'll let Angela talk about the process from here.
She did a little bit.
You did.
Yep.
You're right. You beat me to it. So really just wanted the opportunity to continue the discussion from last month. As we said, we have actually done a lot of research and had a really robust process in our recruitment of the staff attorney position and went into that with succession planning in mind. And your chair here participated in that process. And I had, as I mentioned last month, feel very strongly that we need a strong legal team, and that was a priority in the budget approved by the board. And so this is a continuation of that direction that we've had from the board going forward.
Thank you. Any other committee member questions or comments?
I have a question.
Please.
So if we don't have a budget to do a recruitment for an external recruitment for a general counsel, we have the capacity to recruit to backfill a position if we promote internally.
No,
So we're gonna be down a lawyer if we promote internally.
well, and that was the plan.
Okay.
So when we did the succession planning, the plan was that, John Marshall would stay on for a period of time to help with the transition with the new lawyers coming in. It was John Marshall and Catherine. We now have Marcia, Graham, and Jack. So we've added to the staff significantly in the last year. With the goal of John Marshall knowing that with the succession planning, like we discussed, that he was going to transition out.
So if we don't promote internally, we're not gonna backfill.
If we do
So-
general counsel. So the challenge would be, we wouldn't have a general counsel if we didn't promote internally.
Right.
So we wouldn't be backfilling the position, so.
Right, so what I'm saying is if we do promote internally.
Right.
We're not gonna
backfill that position that we're promoting, correct?
Correct.
So basically, we would be fully staffed. The plan was to only fund two positions, as I understood it. And John was basically on a short-term extension, knowing that we would end up with only two positions. I think that's what, that was the way I understood it.
That is.
It's also my understanding that John would be amenable to coming back on a contract basis if necessary.
He would help
So-
continue with the transition, I believe.
Well, even beyond the transition,
Yeah,
I think he would be willing to come back on a contract basis.
If he doesn't change his cell.
If he. That's right, if we're not able to contact him, that is.
Off into the wild blue yonder.
Just kind of kind of an insignificant question. In the minutes, we were talking about John making his resignation effective on October 25th, which happens to be a Friday. We're making it effective on the 24th, a Thursday.
He
Is that?
said, yeah, his actual letter indicated the day after the governing board meeting in October.
Okay,
It's also Nevada Day.
all right. Oh, okay, that's significant, all right.
Yeah.
So he would be off, he would be on vacation, all right.
Fully enjoy the holiday.
I see. Hopefully not on a bicycle. Yeah. Okay.
Yes, Madam Chair, if I could just clarify the budget question, I think we got to the bottom of that, but it actually, it was a good problem to have because we had wonderful applicants and talent, and we had not even budgeted for the position that Jack has, in addition to one additional staff attorney, and Marcia was kind enough to be a permanent employee versus contract. So it was a creative approach to succession planning, because we really felt like we needed John's institutional knowledge as long as we could have it. And so we made the budget fit that need, but we were the board to decide to, good morning, to promote internally, we would not backfill, just to close the loop on that. But we are fully staffed in a much more robust manner than we've been for many years. And that was, I think, the bottom line I wanted this committee to hear was that we know our, enforcement needs are great in the region. That goes hand in hand with the legal team, in addition to an uptick in litigation. So I feel confident, as your director, that this approach actually bolsters our strength in the legal area.
Okay, this was the plan all along. Sounds like this was the plan all.
Yes, it
Okay.
was
I'm doing.
well pondered.
If your point is we need more lawyers, I always agree with you.
We have a new general counsel. I want to make sure they have a full complement of.
Yes.
Support.
Yes.
That's good. Thank you, guys. If I'm not seeing any other questions or comment coming from the committee, I will now go to public comment on this item. Let's start in the room. If you have public comment on this item, please come on up and address the committee for 3 minutes. Okey doke. Let's go online. Catherine, is there anyone online?
If any member of the public online would like to make a comment, please raise your hand now by clicking the raise hand button at the bottom of your screen in the reactions menu. And you will be called on and unmuted. Madam Chair, there are no hands raised to comment.
Okay, then if there's no further discussion, I would entertain a motion to recommend governing board approval of internal recruitment to facilitate the transition of general counsel.
So moved.
Thank you. We have a motion, any discussion? And I think we need a roll call vote, please.
Yes, please. Ms. Faustinas?
Yes.
Ms. Loomer?
Yes.
Ms. Aldine?
Yes.
Mr. Keycapper?
Yes.
Ms. Williamson?
Yes,
Madam Chair, the motion passes.
thank you very much. All right, should we get Graham back in? I got it. Oh, thank you. And then can we, okay, we'll have a chair then too. Okay, great. All right.
I'll go get it.
Thanks, guys.
They have plenty of options. Yeah.
Since Graham's not on this, probably okay to start? with?
Yeah,
You want me to wait?
I think it's okay.
Okay to start? Okay, Graham, we can start. Marcia's the main presenter on this one.
Okay.
All right, so let's move on then to agenda item 5, which is appeal of denial of application to reevaluate the IPE score at 1341 Tata Lane, South Lake Tahoe, California. Assessor parcel number 032261002, TRPA file number ERSP 2023-0033, and appeal file number admin 2024-0011. Information on this item can be found on page 133 of your packets. As a reminder to the public, after board discussion on this item, we will be taking public comment at 3 minutes per speaker. At this point, if I could please ask Marcia Birch to present for staff for 15 minutes.
All right, good morning. I'm Marcia Birch, Associate Counsel, and I'll be presenting staff's position on the appeal. We can go to the next slide. The staff recommendation is to deny the approval and affirm the executive director's decision to deny the application for reevaluation of the IPE score. So the issue on appeal is whether the parcel is subject to reevaluation under code section 5363. So this is a very specific analysis that's specific to this code section. So I just want to remind folks of that. This is a pretty technical area. Whether the application for reevaluation represents a challenge to the application of the IPE criteria is something that isn't subject to reevaluation. And a challenge to the application of the IPE criteria is limited to the filing of an appeal. So immediately after these parcels were scored, there was a 90-day appeal, 180-day appeal period. And then a little later, the code actually provided for a second appeal period. So there were a couple of, that was in 1990. So, we can go to the next slide. So I'm gonna do a very brief overview of the land capability classification system. I know for some of you, this is old information, but for some of you, it's pretty new. So hopefully, I will get through this pretty quickly. So the Bailey system was developed for residential, multifamily, and commercial parcels. And the IPE system is for undeveloped residential parcels. In 1969, the Bailey land classification system was adopted. It has land districts ranging from 1 to 7, with the less sensitive classes being the lower numbers, so 1 through 3, pretty sensitive lands. And due to the unique qualities for stream environment zones, those have a separate, it's a subcategory of sensitive lands. So over the next decade, the gains were not sufficient. So the compact was amended in 1980. Those new restrictions resulted in the 1984 regional plan, which was challenged relatively immediately after adoption. And by 1987, the new regional plan included the IPE system for undeveloped residential parcels. It's an objective system. It rates the relative environmental suitability of vacant residential parcels for building. Scores range from 0 to 1150. SEZ parcels are given a score of 0. Over the next few years, between 87 and 89, all of the vacant, or most of the vacant parcels in the basin were scored. There were about 13,000 of them. Parcels with the 0 score are not buildable. And so how TRPA manages parcels that have a score greater than 0 is not necessarily relevant to this parcel, but it's relevant to the overall system. So I'm just going to give you a quick overview of how that IPE system functions. And so we have the 0 scores, and then there are parcels that have a score ranging from 0 to 1150. Under the 87 plan, only those property owners with an IPE score above the IPES line. And I believe the initial IPES line was 725. Staff might be able to confirm whether or not that was true, but there was a number, and above that number, you were eligible to seek an allocation for, constructing a residence on the parcel. So that IPES line is something that our code addresses. Each county, based upon a formula, there was a number, and if the parcel score is over that number, they're eligible to seek that development permit. TRPA conducts an annual review for each county to determine if the IPES line should be reset. And the formula that is applied is a vacant lot equation. So it measures the countywide proportion of sensitive parcels available for development. So for example, the vacant lot equation must drop to 20% in California and 33% in Nevada before the IPES line is lowered. So if that IPES line is adjusted based upon a number of criteria that the agency applies to it, then that ratio of sensitive parcels is shifting. So retirement of sensitive lots is one of the ways that ratio shifts, and that happens through agreements, conservation easements, acquisition by the public, that sort of thing will result in the retirement of sensitive lots. So that's sort of the IPE system in a nutshell, and staff is here as well if you have questions in a bit. So we can go to the next parcel. So this kind of just repeats what I just said. They're looking in the scoring of a lot. They look at site-specific criteria. And most of the vacant parcels in the basin have been scored. Okay, you can go to the next one. So the process for challenging an IPE score, the code provides for 2 methods. There's the reevaluation that was applied for in this case, and there's appeal. As I mentioned, the time for appeal passed a long time ago. There are mechanisms today. If you have a vacant residential parcel that was never scored for some reason, you can apply to have it scored. So if you had it scored today, then your appeal period would begin to run after your score was granted. But for those that were scored in the late 1980s, those appeal periods have long since run, almost 30 years ago. So, and there's a specific appeal period provided for in the code. And so you can go to the next slide. So reevaluations are only available if there is new information that was not known to or considered by the ICE team at the time of the evaluation. And I think the critical piece of this code provision is that it expressly prohibits reevaluation on the basis of whether or not the IPES criteria were properly applied. So there have been circumstances where TRPA there was one in 2007 where there was some new information that was not available to the IPES team at the time that made it clear that they had scored the adjacent lot. Right, so they had misscored it in the sense that they had evaluated a different parcel and applied the score to the parcel of the folks who had applied for reevaluation. So in a situation like that, where you have new information that indicates that the wrong lot was scored, or, you know, there was some other problem, then that would trigger a reevaluation. And the truth is, there are a very limited number of circumstances that I can imagine where a reevaluation would be granted. In this particular case, we'll go to the next slide. So the Wendell parcel, it's a pretty typical size for that neighborhood. It's 16,300 square feet. It was scored by the IPES team in August of 1987. During that time, as the IPES scores were issued, the owners were notified and provided with information on how to appeal the score. The soil profile was described and a score was given. The IPES evaluation verified that the entire parcel is stream environment zone in the case of the Wendell parcel, and it was given a score of 0. The appellant's predecessor did not appeal the IPES score and it became final. And in 1991, the appellant bought the parcel for approximately $8,000. So we can go to the next slide. So this is what the field notes look like from the IPES scoring team. And you can see there where it says it's 100% SEZ. There are some questions and we'll get to them in just a little bit, but I want to point out where it says at the very bottom there on the left-hand side, it says access through SEZ and it's marked no. And then utilities through SEZ and it's marked no. So this was an undeveloped parcel. It did have an existing site on it that had been graded. And we can go to the next slide. And you can see, this is very messy field notes, but you can see that where it says there in the upper right, it says graded and it's underlined. And there's this kind of shaded area that someone drew in with a pencil. There's another area near there on the left-hand side that's identified as a seep. So the IPES notes, as I said, indicated it's 100% SEZ, that a foundation was graded on the parcel. A 20 by 30 foot seep existed at the front of the parcel with larger areas having, quote, moist indicators present. The existence of the wet site vegetation and the soil test pit with strong bleaching at 32 inches. All right, so we can go to the next slide. So the appellant's assertions on appeal are that a new survey indicates that the site had been graded before the IPES scoring took place, and that the soil pit used in the IPES scoring was located in the previously graded area. And the second assertion is that the IPES field notes indicate that the access and utilities for the site were not located in SEZ. And in the appellant's position is that this indicates that the IPES team made an error and that they just were confused about the site. So we can go to the next one. So the new survey is not an appropriate basis for reevaluation because it would represent an impermissible challenge to the application of the IPES criteria. In other words, whether the initial IPES evaluation team properly considered the previous grading. The previous grading was something that was identified, it was known at the time, so it's not new information that the parcel had been previously graded. During the last 30 years, many sites have been altered from either man-made or natural changes on the property, such that today's surveys cannot be relied upon to indicate that the topography of the site what the topography of the site was in 1987. So there are some modern survey techniques that are probably more precise than what was used at the time. But there's no information suggesting that they were on the wrong lot. There's no information suggesting that they weren't aware of the grading that had been previously done in what appears to be maybe the location where a foundation was anticipated. So we can go to the next slide. The 1987 field notes, they include those check boxes indicating that the access and the utilities were not located in SEZ. And the point that appellant is raising is if the entire parcel was SEZ, why did they mark those boxes as no? It's possible because the access had not been created at that time. There may have been an area identified where the access would go. The access, it was not in existence at that time, and there were no utilities to the site. It may have been that was the reason. I mean, we're at this point, the fact that those two boxes were checked was information that was available to the property owner at the time they got the IPE score. Certainly an appealable item if they felt that that was incorrect. Okay. So we can go to the next slide. And this is, because these are very strict rules, it's something we really need to understand in the context of the overall land capability system. It was adopted in 1987. The land capability system was developed and adopted to meet the compact requirement that TRPA balance growth with environmental quality. And this was something that was done because it was a directive in the compact. It was also very much impressed upon the agency by the Ninth Circuit Court of Appeals when that 1984 regional plan was challenged. So the IPE system was developed specifically to balance the growth with the environmental quality. So the level of development allowed in the region is based directly on the number of sensitive lots that were identified in the initial IPE's evaluation. And the number of those lots that have since been retired. So as the lots are retired, that overall number in each county is a critical number that sort of the entire IPE's land capability system rests on that initial, the identification and the finality of those scores. If new information, if a new survey today can be used to challenge the application of the IPE's criteria today, it would be inconsistent with the clear language of the code. And any IPE's parcel could be reevaluated, undermining the existing balance and percentages in each county, effectively doing away with the IPE system. The land capability system was subject to nearly 2 decades of litigation. This is partially due to the fact that the scoring system does lead to significant limits on development. And in the case of SEZ, the parcel is unbuildable. What may appear to be a strict result is the direct result of carefully crafted system that clear rules have been upheld by the courts. So that is hopefully 15 minutes and that concludes my presentation. And I think that the appellant is here to do a presentation as well.
Yes, thank you. If I could please invite Mike Dill up for the appellant, and you have 15 minutes, sir. And we can, let's make sure you get cozy with the chair.
There we go. Catherine, you have my slides?
I do, yes.
Thank you so much. Good morning, Mike Dill, Aspen Environmental Services. I'm here to represent Mr. Wendell, who's in the crowd. Also Joe Pepe, the previous IPE's field crew staff member from TRPA, is here to also give a brief presentation. I want to start my presentation by highlighting that I think this is pretty straightforward and simple in that if you look here at the highlighted language in chapter 53.63, it clearly states that a property owner receiving a score under IPES may request a reevaluation based on the existence of information that was not known to or considered by the evaluation team at the time the evaluation was performed. In 1987, there was no computer-assisted topographic surveys. That technology is now in place, and we have a survey, Catherine, if you could pull that up, that shows the site. It's a couple more in if you don't mind. I'm looking for the survey. There you go. So this is the topographic survey that was prepared by Jeff Turner, Turner and Associates, licensed land surveyor. It's interesting, I included the soils pit that was made in 1987. And when I first looked at the soils pit location, I thought, well, that's a weird location for a soils pit. If I were the field crew, why would the pit be in the middle of the parcel? That pit information was taken off the TRPA field notes. And quite frankly, that's right at the setback line, the 7-foot setback line to the parcel. So that's not where the house would be built. You'd build the house in the middle of the parcel. So staff, with the information they had, they scored the parcel correctly. But if you take into consideration the cut, if you could take into consideration the soils pit location, you'll find that it's not representative of the parcel and the land capability and or the stream environment zone. One of the most important things I think that's been overlooked is that when you score a site SEZ, you dig a soil pit. If modeled soils or groundwater is found within 42 inches of the surface, it's considered SEZ. In this case, the field crew found the soils pit, they found modeled soils at 33 inches. Well, that's 33 inches from the existing grade, not 33 inches from natural grade. If you add the additional 36 inches from the cut, that modeled soils would be found at almost 65 inches below grade, well below the threshold of 42 inches. So if it had been applied correctly, if they had the information of the survey, they would have realized, yes, you have a 3-foot, possibly even 4-foot cut from natural grade. So that IPES criteria was not applied correctly, but that was the information they had. Catherine, could you go to the next slide? In 1987, the TRPA staff used the assessor's maps, a scale of 1 to 100, or in the next slide, Catherine, you'll notice scale of 1 to 400. In the bottom left corner, it's hard to see from here, but the assessor's survey maps say these maps are prepared for assessment purposes only. They're not to be used for delineating SEZs. So when you look at a map like this or the previous map, you'll see there are no natural features, there are no trees, there's no designated cuts. None of the topographic or site information is available to the field crew. If we could go back a couple to the original survey, I would appreciate it. Thank you, Catherine. The pit location, well, you can see there that where the red circle is where the field notes the soils pit location was taken. If you look at all the other X's across the board, they're all in the middle of the parcel. Why did they score this? Why did they put the soils pit there? I think the field crew was confused as to where the parcel boundaries were. So Marcia had brought up that in the previous cases, in 2007, the TRPA did a reevaluation because they found they were on the wrong parcel. Well, in this case, it looks like they were on the right parcel. They just scored the area wrong. And so it's back to the simple question is the topographic survey new information that would facilitate the score and facilitate the field crew? It wasn't available in 87. They're using a 1 to 100 or 1 to 400 scale map. So they applied the criteria with the information they had. And we can't argue that. We're not looking to appeal this. We're asking for a reevaluation based on new information. We have a new survey. It's clearly information that was not available in 1987. Can you go back to the survey, Catherine? There you go. It's hard to see from here, but on the field notes right there, the pit location was at elevation 105.5. Natural grade was 108. So almost 30 inches above. And again, if you take the simple math of the threshold for SEZ is 42 inches. Well, the field crew found it at 33, but if you add 30 inches, that's 63. So if you had that appropriate information, as this new survey provides, the scoring would be different. And this would be a buildable lot. I'm happy to answer any questions you may have. Again, Mr. Pepe would like to speak, and I know Mr. Wendell would as well.
Well, how much time are we at?
6 minutes.
6 minutes remaining.
Sorry, it's been 6 minutes and 44 seconds.
So if Mr. Pepe or Mr. Wendell want to speak for the balance of 15, they're welcome up.
Excellent, thank you.
Oh, I'm Joe Pepe. I was sole scientist and I was involved with the pipes from 1989 and 2000. And the only point I would make is that if I had a detailed information, usually these site plans like this are brought forward when you submit a request for building. And it's good information. And I agree with Mike that I probably would have looked more in the middle of the parcel. I think they looked at that cut slope as a way to facilitate getting the information in a timely fashion. But the ICE team that went out there, I mean, they looked at the topography as it existed. And it had been that, my understanding, that way for since the 1950s, it was graded. But if I had been given the opportunity, I would have looked at this lot. I wouldn't have scored it a 0 because they don't have the 3 secondary indicators required to be an SEZ, but of course, that's an appeal issue. Would have had to been taken care of with an appeal within the time frame. So that's basically all I had to say.
Thanks, Mr. Pepe.
Thank you all for reviewing this case. I have not much more to add other than the fact that this lot was always intended to be built on even by the original owner, Earl Natras, who I came to get to know over the years. He intended to build a house there. That's why there was a cut. That's why it's a man-altered lot. Had the field crews had this information that we're now providing, this detailed topographic survey, the calculations would have been completely different. So the intent of the previous owner was to build on the lot. He just never got to it. I was lucky enough to get that lot from him as he owned the house that I bought. So he owned the house that I own and the lot next to it. I purchased both. With the intent to someday build on it when I retired. I am now in that position. I've been told and led to believe throughout the entire ownership of this parcel that it would be an easy, quote unquote, straightforward reevaluation based on the obvious. If you look at the lot, you can tell it was always designed to, or always intended to be built on. Whether intent has plays any role in this or not, I don't. All I can do is rely on experts in the field. I happen to be an expert in BMP implementation. And I've done many projects with TRPA oversight. So it's not that I don't understand how the implementation of BMPs and soil grading and soil classifications go. I do. I understand it quite well, actually. In fact, I've won on a TRPA award for best of BMP implementation back in the 90s at Fallen. So my goal was always to wait until I was in a position to be able to reclassify this lot. I'm now in that position and I'm going to vigorously pursue this because it's, we've provided the information that was requested of us for a reevaluation. If it boils down to a matter of semantics and a matter of how you interpret the wording of policy and so on, that's beyond my understanding or control. All I can do as a homeowner and as a landowner and as a potential developer of this property is put my best efforts forward to rectify the mistakes that were made in the past. Not to anyone here's fault or my fault. Mistakes were made. That's what happens in careers. If I made a mistake in my career, I fixed it. I took responsibility for it and dealt with it. So all I can do is thank you for hearing this case, and hopefully this new information that we brought, by quite expensive, I might add, to have Jeff Turner himself came out and did this. I actually helped him set up his instruments to do this. He had to actually triangulate from hundreds of feet away to get accurate measurements of this lot. I mean, it was quite frustrating for him the first day. He spent 2 days doing this topo, and had to go hundreds of feet away to neighboring properties to find markers that he could then triangulate and accurately, plot these corners of the lot. And his statement to me was the same that we're presenting. He said, this is not an SEZ. He said, clearly it's not an SEZ, and any other classification other than buildable lot is simply incorrect. And he said, let me know if, you run into problems with this, because I'll be glad to, share that information. So, I didn't ask him to come today. I'm sure he would have had I asked him, but I think that his reputation speaks for itself. If he's the foremost authority on surveys and on topographic. I mean, if you look at that survey, that is detailed. That shows exactly what that lot looks like, including trees and everything else that are on the lot. I might also add that since my ownership of that lot, which has been 34 years, improvements have been made to that property. I don't know how that plays into our current situation that we're in, but we've definitely made improvements. I put BMPs in place. I've done bank stabilization. I've done water mitigation, and the lot absorbs water very well. I mean, I know it's not an SEZ. I've worked on SEZs for 45 years at Fallen Leaf Lake, and this is not an SEZ. So that's really, I don't think, the point that we're trying to get. All we're trying to get across is that the information that we have provided is some new information that's not available to them. By virtue of that, we should be granted a reevaluation of the property.
Thank you.
Okay.
And at this point, Marcia, 5 minutes for rebuttal if you'd like.
I would, yes, and what I'm gonna do, and I should have done a slide for this, I'm gonna read the entire code section, because this is really critical. It does address new information, but it has very specific limitations on that. So TRPA, or the owner of a parcel receiving a score under IPES, may request a reevaluation based on the existence of information that was not known to or considered by the evaluation team at the time the evaluation was performed, such as existing access easements and lot consolidations. Reevaluation shall not include determination with respect to the IPES criteria being properly applied. That determination is included under an appeal. As we just discussed, and I think it becomes fairly clear, there's new technology all the time. There are changes to the environment. There are man-made changes. There are natural changes. There will be new information. But that new information cannot be regarding the proper application of the IPES criteria. The location of the test pit, the conclusions that were made regarding the soils, the level at bleaching. We don't know whether or not the IPES team was aware of how far below the natural grade. They didn't have the modern technology, but they did have technology, and they did work to survey these parcels. And so we can't sit here today and say this IPES team didn't know how, whether or not there was 30 additional inches at natural grade. And the reason the finality, the need for finality in these IPE scores has been tested, through the judicial process many times. This went through, almost 20 years of litigation in the, Ninth Circuit. This is a strict system and it did allow for appeals. The original owner, if he intended to build on the lot, he didn't appeal his score. And he didn't appeal it again during the second window of opportunity in 1990. There was another opportunity to appeal your score and he didn't do it. So I don't know why, but if his intent was to build, he had those appeal opportunities and didn't take them. And so I think that, the last thing is, if we can go to the slide, that showed the X's where the soil pits were. Several of them are, on the edge of the lots. You can see them down in that lower kind of right-hand area. They're not all in the center of the lot, and I don't think that there's anything about the location of the soil pit that would suggest today that they were on the wrong parcel. And that's all I have in rebuttal, and if you have any questions, I'm happy.
Yeah, committee questions, comments?
There's an X on that, on the lot in question as well.
Right.
Why is that X there if the soil pit is in a different location?
Because it's unbuildable, I presume.
Yes, and I will say there are a couple of lots in the area very close to this one that are also 0 scores. There were several in that neighborhood. I suspect some of them may have been appealed. I don't know that. And those, all of those 0 score lots in the neighborhood are assessed by the county right now. The assessor's value is $13,000. There is another, I'm sort of speaking to what one might think of as, an investment, right? And so this parcel was definitely priced at a 0 score lot price, right? So when it was purchased. So.
Shelley?
Marcia, in the letter dated February 10th of 1989 by Bill Morgan, former executive director of the agency, this went out, I'm assuming, to property owners who were impacted by the newly developed IPE scoring system. It says changes to IPE scores. There are provisions for the IPE score of a parcel to change other than by appeal. TRPA can change IPE scores if ongoing water quality monitoring programs detect a significant change in the water quality of the area in which the parcel is located, or if local government implements new projects which reduce runoff and erosion problems in the area of the parcel. If changes occur related to the condition of the watershed or erosion control improvements, TRPA will notify property owners of changes to their IPE scores. Now, obviously, there are properties adjacent, the 2 properties adjacent to this parcel have been, I presume, they were not deemed unbuildable. I don't know if they've been developed or not. But I mean, it's not unusual for water quality improvement projects to help elevate IPE scores. And so I guess my question is, maybe this is an unfair question to ask you, because you're probably not intimately familiar with this neighborhood, but I mean, there is a path forward if in fact improvements have been made in this subdivision that would help to elevate the IPE score and help perhaps to render it developable, because now, it's no longer considered water influenced.
So during the process of evaluating whether or not the IPES line should change in a county, one of the factors that's taken into account is whether or not there have been water quality improvement projects. So those are essentially would be sort of agency initiated changes to IPES score. I'm not aware that that has occurred, right? So what the letter is saying is that, that's in the realm of possibility for the agency to, undertake a water quality improvement project or approve one and then say, maybe this needs to be readdressed. So I think one of the things that's kind of an overarching question here is, what we're talking about today is the application of the code as it exists today to this circumstance.
Right.
And in this circumstance, I don't believe that this is subject to reevaluation. Should there be a time when the agency revisits, the way that, the IPES system is going to move forward? Possibly. And, if we if there are water quality improvement, projects or other projects that in a particular region that the agency wants to take into account and move forward with, we could do that. At the moment, though, none of those projects have, gone to that point where there's been an agency initiative to say, let's revisit the IPE scores in these areas.
So follow-on question to that, so what would have to happen to cause a reevaluation? Is it because we have an opportunity to look at several parcels that maybe, rise to the top as being potential for reconsideration, or, what causes that reevaluation? What will potential that?
You mean a reevaluation of the system?
Right.
Well, if there are enough examples of, a situation where, potentially the water table has changed, or, I can't think of examples, but I do think with the drier climate and the warmer climate, there are probably going to be shifts in, wetland areas. But it would have to be a wholesale revision and sort of reassessment of the IPES system, because the system relies so heavily on these ratios.
Right.
The percentages between, all of the sensitive lots have been identified, and there was such an extreme need for finality. And the reason for that need was because the system moving forward 100% relies upon this ratio of retired, developed, the sensitive lots. And so, the question is, at some point, does it need to be revisited? That's a much larger question than what we're addressing here today.
But the IPES line can move.
Yes.
I mean, and that's built into the system. So, and I'm not saying it's not something the TRPA should initiate, but I think that maybe with, the applicant should confer with El Dorado County to find out, if there are any potential water improvement projects in the offing, in this area, that might have a beneficial effect on the buildability of this lot.
So in addition to, the land capability and then the IPES scores, there's this SEZ, which is sort of a subcategory in and of itself. The 0 score is unbuildable, not just, in this portion of the code, but there's just an SEZ lot is not a buildable lot. There are some situations where if there's shoreline revetment that needs to happen because it's eroding and that sort of thing, there are some exceptions, but they're narrow. So even if the IPES line were to drop, the 0 lot is not going to become a buildable lot.
Well, but you can have a lot, Marcia, that is partially influenced by an SEZ. I mean, there's a provision here in the same letter that says in cases where the only reasonable access to an otherwise buildable site on a parcel is across an SEZ or SEZ setback, development for access may be allowed.
Yes,
So
that's
there-
another exception.
There are provisions. So
Yes.
I guess what I'm saying is that there may be a way forward, without upsetting, the IPE system or the safeguards that have been put in place, but that could benefit the property owner. But it's going to take some initiative on the property owner's part to explore those options and determine whether or not there have been any water quality improvement projects that have been initiated. Are there any that may be initiated based on, similar, I don't know how many of these lots have been acquired. I mean, obviously there was the Burton-Santini Act that acquired a lot of these undevelopable lots. Don't know how many of them, might benefit from that sort of water quality improvement project, but it's not something we can resolve here today. I understand
Right.
you wanting to keep these controls in place to be consistent and to honor the system, but I'm just trying to think of a way forward for the applicant if in fact conditions have changed that would warrant a reevaluation. And clearly that was the directive that was been given by Bill Morgan, that the IPE scores can change with changing environmental conditions.
Which was his thought on that subject at that time. Right, and I think, today what we have is the code, the reevaluation code provision, which I read to you, which is pretty limited. If it's related to, the application of the IPES criteria, it's not subject to reevaluation, and my take on that letter is that it's a use of the term reevaluation, not in the same sense as the code section.
No, but it relates to improvements, helping to raise the IPE scores on certain lots. I mean, that is built into the code. So lots that were once deemed undevelopable may become developable when those improvements are made and those scores rise. So that's not, that's not antagonistic to the code. And I think that, people were led to believe certain things based on correspondence with the executive director at that time. And I just think I would encourage the applicant to look at that as a possible path forward. So.
If committee doesn't have questions or comments, I'm gonna go to public comment. Any members of the public wishing to make comment on this item? Catherine, is there anyone? Oh, come on up.
Morning, everybody. Right. I just have a question, or an observation and a question. So the question, I guess, is to your legal counsel. I thought I heard her say that they didn't know what the field crew was thinking at the time. So there's new information that says that the grade is at a certain level, but the pit was dug at another level. So to me, I don't understand why that's not new information. If you don't know what the field crew was thinking at the time. So I think they presented some new information. Secondly, has anybody been down on that property from this group? It's out of curiosity. So from Lake Tahoe Boulevard to the lot, it's about 1.5 miles. Every single lot on the east side of that street is developed. This is the only lot. I don't understand how one lot at the top of the street could be that still. And I'm thinking about the equitable between development and environment. So maybe somebody can try to help us understand how one lot in 1.5 miles is the only lot that's not buildable. So only lot that's zero. And there's a lot that was just built for $1.5 million, 2 doors down. I just don't. The logic, I understand what your attorney said, and it seems like we're trying to not breach any exceptions to open up another box or open up another can of worms or whatever the case. And it doesn't seem to me that we're looking, or legal evaluation was open to anything, was not open to any new information. That's.
Catherine, could you bring up the map that has the field note map? That has these various lots. I'm just kind of curious. My assumption was every lot that has an X on it was deemed to be undevelopable.
I don't think so.
You don't think so? Well, no, but I mean, they were Xed off for some reason. In addition to this one, they all bear an X.
It could have been that those are the ones they had finished.
They had finished
sorting.
okay, so.
I mean, we're really speculating on much of.
Yeah, no, I understand that, but what you're saying then, if the gentleman could just come back up to
Every single lot on the side of where the parcel is in question is developed and went all the way up. And that's the only.
It's the only lot in that string of lots that is not
Yeah.
developed.
Correct.
That's a little
I just
suspect.
doesn't- How can one lot in 1.5 miles?
It's.
Some of these properties have been developed before IPES came into being. So a lot of the properties are grandfathered. I mean, this is.
Developed. I mean, 2 doors down.
Two of them just got.
Yeah, and that, I mean, it's common throughout the basin for there to be this type of situation. My parents live right next to one as well, where they bought for $3,000. It's a common thing, and the pricing of these properties is really built into that scoring. So when we talk about, I mean, I understand the comment, but again, none of us really here were the ones that created that. But in terms of the investment backed expectations that people have when they purchase these properties, it's kind of built in. The other thing I would say is just observing, when we're talking about new information, anybody, if you could just make a, create a new survey and call that new information, that's a big change in what we're talking about. And if you think about it differently, the land was always there. That's not new information. Maybe it's a new survey, but it's not really new information. So kind of what we're talking about here is just that, hey, they did it wrong. And we have long interpreted that to mean, that's an appeal, which, as March has explained, is long since passed.
But Graham, I think to my previous point, if a house in close proximity to this lot has recently been developed, what improvements have been constructed that may help to elevate the IPE score on the lot? But that's something that the applicant has to investigate, and I would encourage him to do that with El Dorado County.
I also want to clarify, there are several lots very close to this one, within a few lots that are 0 scores. There's one at 1340 Tata Lane, which is on the same street, that is also a 0 score.
On the other side of the street.
It's on the other side.
So, but it's not a mile and a half away. So I guess what I'm saying is it's.
Okay.
There are 0 score lots in this area. We don't know whether or not some of these were scored 0 and there was an appeal. And that's possible. So I do, and the idea that it couldn't possibly be accurate that it was SEZ, there were definitely other lots in this area that were scored as a 0 score as well.
Okay,
I do have a hand raised online.
please.
Alan Miller, go ahead and make your comment.
Hi, I'm Alan Miller, civil engineer, former employee with California Regional Water Board. 25 years. I worked all kinds of wetland projects, stream restorations projects. I know a lot about this. I've been to this lot, seen this area. I find this whole discussion just ridiculous. I'm really hard not to get incensed over it, because with all the abuses of TRPA's discretion I've seen in my lawsuit, Miller versus TRPA, Marcia Birch and her corrupt presiding over the hearing at the Eisenstecken appeal, just ridiculous, standing on these narrow legal grounds to deny this property owner reasonable accommodation for his request. Other than Ms. Aldine, I just think this whole thing is just outrageous. Just ripping this guy off. This parcel is not SEZ. This entire parcel could never be classified as SEZ today. It's based on that damn cut and their stupid evaluation, and TRPA just can never admit they make a mistake. But they stand on these narrow legal grounds and they twist the law and they twist the interpretation, and then they say, okay, buddy, we'll see you in court. If you don't like it, sue it. So TRPA wants litigation, good. They should get a lot of it, and I hope they get a lot more. And that's about it. They should give this man his due, and they should score this lot appropriately, and he should be able to build a house on it. It's ridiculous. Thank you.
Anyone else?
There are no other hands raised to comment.
Okay, I will,
I'd like to make one quick comment. I do not know who Alan Miller is. I really do not. Never met the man. And so I don't know what interest he has in this, but.
It's on your property.
I mean, so just that as an FYI, I did not solicit his comments.
thank
but
you. Thank you.
I don't necessarily disagree with some of it either.
Any other further comments from the committee? Otherwise, I will look to entertain a motion, a reminder, that I need a majority of the quorum present, and the motion would be to recommend the governing board deny the appeal. So I'm looking for a motion or discussion, guys.
On discussion purposes, I think that they make a pretty compelling case that it's probably that could have really influenced designation of this as an SEZ. But considering how considering this system, how it's been litigated over decades, and the need to sort of maintain the integrity of this process, considering the broader impacts throughout the entire basin. I worry about, doing anything that may deviate from our code when it comes to what constitutes, an appeal or new information. I worry that just a new survey isn't really new information. Anyone could go out and that it would sort of set the precedent that anyone who's got a 0 score could go out and do a new survey and then automatically be eligible for reevaluation. I think that's a dangerous precedent.
Yeah,
my husband is.
Member Keycapper, you just explained exactly where my head's at.
Yeah.
I feel like that grade probably really influenced it, but I also worry about the strictness of our code and the application of those words. And opening that.
Yeah, but I think that overall, I'd be frustrated as well if I were the property owner.
I'd like to suggest that the property owner request a continuation. So perhaps they can explore the idea that there have been water quality improvements in the area that may have rendered this lot, may have rendered this lot more buildable and therefore would allow the IPE score to rise.
I certainly agree with that. So aside from the topographic survey, the detailed topographic survey, we also dug our own soil pits, Mike and I, by hand, 4 of them. And in the area that a building would be built, none of the criteria showed up in our soil pits, and we dug them deeper than the TRPA dug theirs. We dug almost 42 inches or something. And we found no bleaching of soil. And the further you go up the lot, the less sanding, and there was no bleaching to begin with. The only possible indicators of SEZ are at the very end, very beginning of the lot near the street. That I'm not going to contest. That would, under most circumstances, be considered an SEZ. Foliage and other factors would indicate that. But as you go further up the lot, there's no vegetation. It's been graded. Mr. Natras, who owned that property, who was working under the Bailey system, he was an out-of-state owner. He wasn't aware of the fact that circumstances changed for him. So he abandoned the project, abandoned the lot, moved out of his house. And I was lucky enough to be able to get both later on down the road. So the intent was always to build on that lot. Had he known about the IPES score and the appeal process, he would have certainly done that. But he wasn't made aware of that as he was an out-of-state owner. When I talked to him about the lot, he said, yeah, I don't know anything about this IPES thing. I was gonna build on the lot, but family circumstances changed and now I live in Arizona. So, if you want the lot, here you go.
So Shelley, I'm
Yes.
wondering though, if we do vote on denying the appeal today, if there is new information, I just worry about holding this open and somehow treating this as the new information. So if there is new information.
That's not what I'm suggesting. What I'm suggesting is, I don't categorize that as new information. There is an ability to rise for IPE scores to rise
Right.
over time based on public works projects in and around the subject property. So rather than just denying him, and getting into a legal contest or, whatever might result as a result of the denial, giving him the opportunity to explore that as an additional avenue.
I guess my thought is, I wonder if he could do that still if we vote on denial. I just worry about holding that open because I don't think it's new information. And I just don't want even that to set a precedent that we're holding this open saying, this isn't really new information, but it might be. Like if there's new information.
That's not what I'm suggesting, Haley. We already continued this once. This was continued from last month, so, and we didn't state the basis for that continuation. It was done, I think, at the applicant's request.
I can speak to that. It's because we were only given a few days notice of the actual agenda. We were told that 14 days was the typical notice for being on the agenda here, and we were given 4 days? Two working days.
We got the staff summary on Monday.
Not accurate.
So, yeah,
That's why it was
so
continued.
it was continued. I think, my recommendation would be to vote on this appeal. And then there is that avenue. The avenue remains open. I don't see that being closed. If the applicant wants to pursue a different avenue and try again. But I do think there's some value probably to voting on this appeal, moving past this, I don't think that would foreclose another, you know, if they want to talk about public works or something like that, something different. Here, we're talking about the location of a hole. And really what Marcia's saying is that that's you know, this is something that we would normally do on an appeal. And that's.
Yeah.
No, I understand the rationale for her position. I'm just saying that, you know, the applicant's gonna have to, you know, incur additional costs because I'm assuming there are fees associated with reinitiating the appeal. And I don't know.
Not our internal appeal process.
There are no fees.
So.
Getting a denial doesn't preclude him from reappealing on the same.
Doesn't
Claim.
preclude, Marcia, if you want to jump in, but shouldn't preclude the applicant or this party from reinitiating an effort with TRPA to talk about this. It doesn't mean that any particular, there's going to be a particular outcome that you know, they might like. We might be back in the same position.
Well, so what I want to do is frame this issue. The question is, they made an application for a reevaluation under the code section that I read to you based upon new information. What I've explained is that it's a challenge to the application of the IPES criteria. So what we need to decide is, have they raised new information that does not challenge the application of the IPES criteria? If so, they're allowed to have a reevaluation. If not, the answer is no, and the appeal should be denied. These other avenues are outside of the scope of this code section. It's going to be outside of the scope of this appeal. So even if we continue it and there's additional information gathered about these other avenues, they're not relevant to the question that's before us today. Is this parcel subject to reevaluation based upon the new survey? And you know, based upon a claim for new circumstances that don't relate to the application of the IPES criteria. So I think that's the question we need to answer today, is whether or not this application was appropriately denied. And if there are other avenues, they are outside of the scope of that particular application.
I think I'm ready to make a motion. This would be a motion to grant the appeal.
No, that's for the
I'm sorry,
governing board.
pardon me?
Here it is on the screen.
Okay, a motion to recommend the governing board denial of the appeal.
We have a motion. Is there any further discussion? Otherwise, I'm looking for a roll call vote.
Yeah, on discussion points.
Yeah.
I'll vote for the motion, but I think that we need to. There will be, I'm sure that it happens a lot, right? That there are, maybe not a lot, but I think we're sort of based on discussion and agreement that maybe this was not applied appropriately in the past. And I mean, there's got to be some way to fix errors that, or things that may have been errors in the past. And just because someone didn't apply 30 years ago for an appeal, I don't know. I mean, I know there are statutes of limitations in law and all sorts of things, but it seems inherently unfair. But I think it's important to maintain the integrity of the system for the time being.
So just to be clear, lots of clarifications. The only new information then is the survey. It's not the new test pits, which haven't been, I mean, the outcome of those test pits has not been disclosed to the agency, right?
No,
So it's strictly the survey.
Yes, if a reevaluation had been granted, then a reevaluation would occur, right? And it would be rescored. So again, this goes back to the finality of that score, and how critical that was to the system. Which is why it did have that 180-day appeal period. It was reopened again for those who missed their appeal opportunity, and was reopened again in 1990. And that was done so that these could be final, right? So if a reevaluation was appropriate, if there was new information suggesting that, you know, they had actually graded the lot next door, and so the score was inaccurate, then there would be a new evaluation, and the new test pits would be relevant at that point because there would be a new score taking place.
Can I say, so if that surveys had not indicated, if the work of the scoring team back in 87 had not indicated that that there was grading on the site, for example. And they came forward with a survey that showed there was grading. Would that constitute new information?
That's a good question. That wasn't what was evaluated by staff because the grading was shown on the field notes. So it was clear that the IPES team knew that the grading was there.
Did they know they were digging in a graded spot?
Well, and that's a question, right? Do we know that the test pit was in the graded area? What, if it was, did they take that into account? I mean, we can't go back and get into the heads of the IPES team. And so, again, you know, they were human, so there potentially were errors, which is why there was the appeal process. There was even a reevaluation process immediately after some of the scores where it was kind of an informal process. So there were definitely opportunities for the landowners to say, hey, I think you might have, you know, misscored my lot. Yeah, I hope that answers.
Yeah, it does. I just, it's a little like somebody who's been, convicted of murder and then appeals and years later, and they find out with new DNA evidence that he's not the murderer. I mean, there is such a thing as being equitable and doing what's right. And I understand TRPA systems, and I understand the delicate balance between, development and the natural environment. But I think if if it could be demonstrated that a mistake was clearly made, I don't know that the property owner should suffer the consequences of bad judgment of this agency. And I'm not trying to, vilify anybody. I mean, they were probably doing their best. There were a lot of lots that had to be evaluated, and I don't know how many people we had on staff at that time, but I just have a hard time foreclosing an avenue for this applicant.
Yeah, I don't necessarily disagree. I mean, the question is, are you willing to accept a new survey as new information?
No, I think the survey, the test pits, frankly, would be more, I think, illustrative of, the fact that this area is no longer water influenced. And maybe that's a conversation for another day, but.
Yeah,
so.
I do think, and there are concerns, and they're understandable concerns, right? We're 30 years on.
Yeah.
And so, maybe these are conversations that need to be had. But right now, we have the code section that we have the process that we have, and it's been consistently applied. And, for the reasons that I've explained. And, there is a point in any policy or program, where maybe it does need to be revisited, but that's not before us
today.
Yeah.
Understood.
Okay, Catherine, follow up. Ms. Aldine?
Yes.
Ms. Fastinas?
Yes.
Mr. Keycapper?
Yes.
And Ms. Williamson?
Yes, and I would also like to remind us all, this is in front of the governing board next. So passing out of this committee, we can have this discussion at the full board level as well.
Well, I think we need
Which
to.
we will do in an half hour here. So mine is a yes at that, and to remember, we can, continue this.
Motion.
Okay, next is agenda item 6, which is closed session with our council to discuss existing and potential litigation. If I could please ask members of the public, we're gonna close session and we're going to move, I don't think we have remote committee members, so we just need to.
I'm gonna get some.
Okay,
So,
thank
Madam
you.
Chair, just.
Yeah.
There you go.
Okay.
Please, thank you.
All right, we're now on agenda item 7, which is potential direction regarding agenda item 6. Graham, any potential direction do we need to talk about?
No direction to report. It was agendized as just an informational update, and that's what it was.
Good deal. Thank you. Agenda item 8, committee member comments. Any committee members have comments for the committee this morning? Great. Let's move on then. Agenda item 9, our final agenda item, which is public interest comments. Ellie, do you have public interest comments?
I do. Excuse me.
You can come on up if you want.
Yeah, so the microphone picks you up. Thank you.
And Ellie, just a reminder, we're gonna do 3 minutes.
Yep.
Thank you.
Thank you. Ellie Waller, I just want to thank Ms. Houston for her assistance and patience in me making requests that I have declined. I'm retired, I'm on fixed income, I can't afford this stuff. That's what brings me here today. I'm preparing comments about the South Shore Area Plan process and the lack of clear direction as related to Douglas County being the lead and TRPA only supposed to be addressing phase 2 affordable housing. Confusion comes to the public when we have questions about violations. There is a sign posted on the Barton property, former Lakeside. I couldn't find a sign permit. I went to Douglas County. I've been to TRPA. Each are looking into it and going to get back to me. The public wants to understand who do they file potential or what might look as a potential groundwater issue in the future. Where would that violation go? It appears that TRPA or someone has done a scenic evaluation. We saw a crane out there to look at height. Who is doing that? I asked for that information. Again, I'm not going to be spending hundreds of dollars getting paper. Eventually I'll get it from Douglas County. Again, if TRPA is doing that scenic evaluation, is that related to the environmental checklist? You know, it's just very confusing to the public about this process. What else do I have in here? A lot of things that are in the area plan that I go in front of the Douglas County Board of County Commissioners appears to be hospital specific. I've asked them to bifurcate anything from the area plan. We'll see how that goes. We do not have a new draft posted of that area plan. So again, just the legal ramifications of where we go. Do we come to this committee? Do I just keep pestering both sides to tell me where a violation is being filed? And I appreciate the opportunity to speak before you today.
Thanks, Ellie. And Catherine, anybody online?
There are no hands raised on the comment.
Okay, going once, going twice, still nobody up. Okay, with that, I'm going to entertain a motion to adjourn, please. All in favor? Aye. Any opposed? We are adjourned at 10:11. Thanks all.